Greetings, family. Peace, love, and positive thinking. This is Guru, and thank you for joining my channel. This vlog today is about necrophilia, a man who is accused of necrophilia and sexual assault who prevails in a privacy case. This is regarding a cell phone, and I'll read the quote. It says, "Cell phones are intrinsically private, Arizona Supreme Court finds." Let's go to the story. In a unanimous decision, the Arizona Supreme Court ruled Monday that the police overstepped when an officer warrantlessly searched the phone belonging to a man who had been an overnight guest at a female neighbor's apartment. According to the 10-page opinion, Tucson police were called when the woman, referred to as DC, was found unresponsive in bed by her daughter. DC had been dating the man who lived next door, Robin Peoples, for a few months, and she had invited him to spend the night. The next morning, while Peoples was in the bathroom, DC's daughter, who lived in the same apartment complex as her mother, arrived. When her mother did not respond, the unnamed daughter called 911. Peoples ran from the apartment to direct paramedics, but inadvertently left his phone behind. Paramedics arrived and began tending to DC, but soon after pronounced her dead. Peoples sought solace, according to the opinion, at a neighbor's apartment. The opinion continued. Tucson police officer Travis Mott came to DC's apartment after she was pronounced dead. He looked for information that might identify DC's doctor, hoping the doctor could shed light on DC's recent health and sign the death certificate. He found a smart cell phone in the bathroom. Assuming this phone belonged to DC, the officer turned it on and opened it with a finger swipe to search her contacts. It was not passcode protected. A paused video image of DC on her back in bed, mostly naked, appeared on the screen. The officer pressed play and watched part of the video of Peoples having sex with a seemingly unresponsive DC. Before he watched the video, Officer Mott had been told that Peoples spent the night at the apartment. Not long after, Peoples returned to get his phone back. According to Officer Mott, after viewing the video, he detained Peoples in his apartment, read him his Miranda rights, and questioned him about the video. Peoples confirmed that he had sex with DC during the early morning hours and filmed it with his phone. Peoples also told Officer Mott that DC, quote, probably was dead, unquote, when they had sex, although he, quote, thought she was breathing, unquote, and had heard her snoring earlier. Peoples later watched the video with other officers and answered their questions. Largely based on the video and his own responses to officers' questions, Peoples then was charged with necrophilia and 2 counts of sexual assault. Eventually, his attorney moved to challenge the evidence of the video found on his phone as it was obtained via a warrantless search. A lower court found in his favor. When prosecutors appealed to a higher court, it ruled in the government's favor. Prosecutors had argued that because Mott believed the phone belonged to DC, who was dead, that there was no privacy interest at issue. They also argued that because the phone was not passcode protected, there was no reasonable expectation of privacy. Peoples then appealed to the state's higher court. But in the Monday opinion, writing for the court, Justice Ann Scott Timmer didn't buy the government's claims. Quote, cell phones are intrinsically private, and the failure to passcode protect access to them is not an invitation for others to snoop, unquote, she wrote. She also wrote that state appellate courts' reasoning conflicted with the landmark 2014 United States Supreme Court decision, Riley versus California. That decision found also unanimously that police could not search the phone of someone who was arrested without a warrant. Quote, the Court of Appeals limitation is at odds with the Supreme Court's reasoning that cell phones contain the privacies of life and are therefore worthy of Fourth Amendment protection, Justice Timmer concluded. Quote, that privacy is no less worthy of protection when a cell phone is outside a person's immediate control. So family, here's the takeaway message. Cops must have a warrant to search cell phones. Rules, Supreme Court. So family, always remember that with your cell phones, you do have a sense of privacy under the Fourth Amendment that the police must respect. And if not, you take them to court and you bring up this ruling from the Supreme Court. Family, I hope you've liked this video. Please share, like, and subscribe. I appreciate you watching. Peace, love, and positive thinking. This is Guru. I'm out.